Good afternoon, everybody. Let's try that. Okay, good afternoon, everybody. Woo. Everybody can take a seat and we'll get started. It looks like waiting a few seconds did help us get more of our members here. Thank you very much to all the members that are here in person and to the ones that are on Zoom. And we do have 3 or 4 of our members dialing in on the Zoom. So I'd like to call this meeting of the Health and Human Services Committee together. And as you know, just to remind everybody in the audience, please turn your phones off. And we are not allowed in this special session to take votes. We were encouraged to discuss bills, but no votes can be taken. But what it does give us the opportunity to do is to discuss important bills that will be coming forward during session and sort of tier them up to move more rapidly as we start in January. So the committee's had time to hear them. First of all, I want to say that while we've been out of session, Representative Schofield brought a bill last session on health disparities. And that bill did not pass, but we wanted to look at that issue. And on September the 27th, we did, bring together a group of experts from providers, community-based organizations, academics, the federally qualified health groups, and faith-based leaders. We spent a lot of time discussing and receiving a lot of detailed information about areas where health discrepancies exist, but also discussion of many of the things that we are doing to try to eradicate the discrepancies. So I felt like it was a good educational process. Thank Representative Schofield for bringing that bill, even though it did not pass. And it helped, to make the committee more aware of chronic diseases and how important screenings and the availability of other services were for our community. So we have done that in the break. Thank you, Representative Schofield. This is as we meet to talk about the Georgia Psychiatric Advance Directive Act. For the members that do not know, and I think this is probably new to most of you, we've been working on this issue for 13 years. Everybody get that? Not 3, 13 years. When we go back in January, it will be 14 years. It is time to give people who suffer from any type of mental illness, the opportunity to have input into how they would like to be treated when they have an episode of their mental illness. Mental illness is just, and I sort of use an example of diabetes. It is an illness, and people that suffer or have been diagnosed with a mental illness often will have episodes, just like somebody with diabetes who perhaps is doing everything they should be, will have a problem with their blood sugar and get into trouble, even if they're trying to do the best, taking the medication they have and doing everything that the doctor tells them to do. They can still have an episode of some kind of a problem with their diabetes. The things can happen in mental illness. And so this is an opportunity for people who have been diagnosed with mental illness to have a say and of how they would like to be treated. Like I say, we have had this going on for 13 years. We've changed it a lot. And I will tell you, we have a group of lawyers and a group of physicians who've now come together with input from other areas that are affected by this. But when you get a group of doctors and a group of lawyers that have come together and support a bill, you have a good bill. And that is what has happened with that. So at this time, I'm going to call Dr. Ash, and who's a psychiatrist, and Mr. Munster, who is with the state bar. If you two would come take a seat, and I'm going to let you, since you have spent the hours going over this with a fine-tooth comb, and if there's somebody else you want to join you, feel free. Want to come ahead. And so you are?
I'm
Dan. So thank you very much for joining us. And then with that, gentlemen, I'm going to turn it over to you, and whichever one of you would like to start out as you review House Bill 752, the substitute, with the committee.
Thank you very much for all your time this morning, Chairman Cooper and everyone else on the committee. I'm Dan Munster, Nick Jurich, Dr. Peter Ash, and thank you for giving us an opportunity to come in and talk to you a little bit about the proposed bill. In front of you, you should have a white paper, and we put that together.
A little closer to the mics. To the mic. There we go. Thank you.
Of course. So the white paper you have in front of you, we put together just as a synopsis of what we're trying to accomplish, what the bill would do, how it would change the law, who would benefit from the law. And I think that if you have a chance to look through that sometime after today, I think it would be a great way to refresh your memory if you need to. So the goals of the bill, this is a very narrow bill. So all it's doing is codifying or adopting a template document and adjusting the supporting statute framework so that it ties in properly with the Advanced Directive for Healthcare. The reason that this is necessary is because the Georgia Advanced Directive for Healthcare expressly leaves a gap. So it says in the document that the agent is not authorized to make decisions related to mental health, as well as a couple of other things. So one of the value adds of this bill would be to close that gap for people who have a mental health diagnosis. It also crosses into two other areas, those with a developmental disability, as well as an addictive disease, and creates an opportunity for them in a very specific and carefully tailored way to create a document which accomplishes a couple of things, which I'm going to touch on in a second. Well, I'll do that now. So it provides patients the opportunity to direct their own care with greater specificity, provides patients an opportunity to appoint an agent to assist with mental health care decisions, similar to our old durable power of attorney for healthcare, now our Advanced Directive for Healthcare. A document can include stated preferences, but it can't include everything. And so therefore it's helpful to include an agent and the creation of an agency to assist with the balance of those decisions that aren't expressly covered. And finally, it will provide medical providers insight about the treatment preferences and history of patients who present in mental health crisis. And I think Dr. Ash is going to comment quite a bit on that, hopefully. By the way, he's kind of the engine behind this, going all the way back to the very beginning. And so I have just been in awe of the amount of time he's put in, and I give you my own round of applause. Great job, Dr. Ash. So why do we need it? As I was saying a second ago, there's a gap in our current law. And so currently the agent under a medical directive, the Advanced Directive for Healthcare, currently does not have the authority to weigh in, first of all, to access records and then ultimately make decisions regarding mental health. And so the goal is to close that gap. Who benefits from the adoption of the Psychiatric Advanced Directive? Well, it's designed for patients who have been diagnosed with a mental or emotional illness, a developmental disability, or an addictive disease who wish to specify and authorize certain treatment they would want when their illness renders them unable to make reasonable decisions. The document does not, before the agent has any authority, before the stated preferences ever come into play, there has to be a decision by the medical team treating the person that they are currently no longer in possession of their faculties to make a rational, reasonable decision based on all the information available to them. So this is not something which will be relied on except in moment of mental health crisis, or if somebody's in a behavioral hospital or some other place for an addiction or other crisis related to developmental disability. So that those are the circumstances in which it would sort of spring to life, the agent would have authority, the stated preferences and consents would be effective. Otherwise, the patient is always going to have their own authority to make their own decisions over and above whatever the document says. So what does the Psychiatric Advance Directive allow the patient to do? Well, the first thing is it allows them to outline their mental health diagnosis and common symptoms. You also can identify historical treatments that have been successful, historical treatments that have not worked well, prescriptions I don't want. This has been a focus, finding a way to create the provision where people can state their preferences and not have it leave the folks in the medical community feeling handcuffed. And I think Dr. Ash will hopefully comment a little bit about that. It offers the patient the ability to specify preferred and disfavored medical providers. So you can actually say in your document, I do want to go to this certain hospital, or please don't send me to this particular hospital. And finally, you can provide advance consent for specific medications, treatment options, and hospitalization. So these are things that are the individual is providing advance consent. And so it's not something that's required and built into the Psychiatric Advance Directive statute framework. There are certain circumstances in which the medical community can choose not to honor what the document says or what the agent is saying in the event that one of those particular statutory points has been triggered. And obviously, those are all of the items in the first section, primary section. There's two core sections of the Psychiatric Advance Directive. One, stated preferences, and the second is the appointment of an agent. And that agent will have, similar to the Advance Directive for Healthcare, access to the individual's medical history and records and the authority to communicate with the medical team, which is making decisions about and providing counsel for the care that is necessary. In terms of the benefits that a Psychiatric Advance Directive offers, the first I touched on a moment ago is just a greater likelihood that the patient is going to receive care consistent with their wishes, as opposed to something that maybe wouldn't have been within their wishes. They also have the opportunity to appoint an agent that they trust, and from that standpoint, there's a greater likelihood that their wishes will be honored. Something that I think Dr. Ash will comment on is that from the medical side, it will maximize efficiency in an emergency. So when somebody presents in mental health crisis, the process of diagnosing them and treating them will be facilitated if there is a document which spells out all of the history, specifies certain drugs that are not preferred, certain drugs that are preferred, and creates a situation where now the medical team has a foundation to make decisions on rather than a blank slate. And taking that a step further, another value is that absent this document, there will be more involuntary commitments, more involuntary circumstances in which somebody is going to have an involuntary guardian or conservator appointed for them. And in this situation, that shouldn't be as necessary, or at least as often, because there already is an agent able to make these decisions. And then finally, from a sort of societal standpoint, I think that Chairman Cooper, you alluded to this, that there's historically been a bit of a stigma to the idea of mental health. And I think that the legislature stepping up and adopting a Psychiatric Advance Directive, which affords all of these folks an opportunity to create a Psychiatric Advance Directive, is basically recognizing this is real, this is necessary, this is something that we don't want to be a source of stigma in Georgia, and that we actually want to provide an environment where you can get good care and where you won't be judged. And we care about it enough that we're going to pass this law and provide that level of support for you. So those are the comments I wanted to start with, and I'm going to turn it over to you, Dr. Ash, and then after that, we can take questions if you.
Or do you want some questions now?
Would you?
Way. It's up to the committee. Do the committee have questions to present or to start off? Okay. What's your number? Okay, Representative Chokas.
You talk about how the individual would change an agent if they were not satisfied with him.
I think the answer is consistent with any other power of attorney in general. You have the opportunity to revoke any document. If it were a client of mine, I would recommend they do it in writing with a level of execution formality as much or greater as the original document. And I think it's more of just a traditional
Yeah, it talks about how you cancel it.
Thank you. Certainly a huge issue. I was curious just to figure out the scope. Does this, number one, does it exclude 1013 patients by the definition of incapable automatically, or will they be offered when they come to a healthcare facility like a hospital? Maybe they're brought there by someone. Will it exclude them in the definition of capable and incapable? Because normally advanced directives are done obviously with every admission to the hospital. We typically haven't offered these kind of choices if someone is brought there and placed on a 1013. That's one question. And the second regarded the preferred facilities that I do and don't want to go to. And maybe you can answer this, Dr. Ash, at the point. We have a huge healthcare access problem, but it's especially acute in mental health, which I'm sure you guys are well aware of. Preferred facilities, I can tell you from Augusta, can be St. Simons, it can be Albany, it can be Atlanta, it can be Alabama, it can be Columbia, South Carolina, when you're trying to find a facility. And if you give too much weight into a preferred facility I don't want to go to, or I do want to go to, I'm just curious, would that tie the hands of us when we're somewhat bound by federal law, Emergency Treatment and Labor Act, just addressing EMTALA and transfers with the preferred facilities, or maybe, and those are generally 1013s, those involuntary committals, which are, maybe they're just all excluded from this. So I'd just appreciate at some point if you can address that, or we can consider it later if we need to.
So with regard to your first question, my understanding is that this document would be in force up until there is something involuntary. And at that point, the mental health code, Title 37, would take over, in which case and of course, Dr. Ash, if your understanding is different, clarify that.
My understanding is somewhat different from how that would work. So a 1013 takes you to a mental health facility. It's a sort of a transportation. Often it's used to actually put someone in the hospital if they have come to the facility. And it basically triggers that it's an involuntary admission. Now, one of the things the advanced directives are trying to do is to decrease the involuntary admissions, so that if the person in their advanced directive, say, appoints an agent, and the agent says, yes, I agree to his going into the hospital, at that point, it's a voluntary admission. So the whole 1013 process drops away. Just as if someone arrives at an ER with a 1013 and you say, well, I think you should go in the hospital, and the patient seems competent to make the decision and says, okay, then you stop the involuntary process. So it potentially can convert a lot of these, what would ordinarily be involuntary procedures, into voluntary procedures. Because if the age, it's like then, if the agent is like a parent, the parent could admit the minor without the minor's consent. And the PAD allows the agent to do that. Similarly, if there is no agent, the PAD may say, under certain circumstances, if I'm this way and that way, I agree to admission. It's a prospective consent anticipating certain times, at which point, again, it would be a voluntary admission and all of the involuntary procedures don't apply. And one of the big problems, I was going to get into in a different way, but I'll mention it now. Okay, all right, okay. In light of this question, maybe to sort of make it concrete, give what I think is a sort of paradigm example of how this works in a particular case. So imagine a person who has what psychiatrists call bipolar disorder, more often known in the lay language as manic-depressive disorder. The typical course of that particular illness is that you go along really normal for periods. Then you have a period of depression and you get back to normal. Then you get a period of mania and then you're back to normal. So when you're in the normal period, you can look at your history and you can make rational decisions about, what you want, what you think you should do when you get manic. Problem is when you get manic and you think, now I'm the richest person in the world and I have no problems and I have a direct note to God and I'm going to go spend all my money, and you do all kinds of things and you say, well, I think you need treatment. And you say, what are you talking about? I control you. You don't have anything to say to me. It's a real problem. Okay. So with a PAD, a person could, Psychiatric Advanced Directive, I'll use PAD because we write it all the way. So with a PAD, then a person in their normal state could say, well, if I get manic, this is what I would like to have happen. I think I should be put in the hospital. In the past, lithium worked or it didn't work, and this other drug worked, and you can sort of lay it all out. And then when you get into, if you hit a manic state and your family brings you to the hospital, then you just get that treatment. You don't need involuntary stuff or any of that kind of thing. And it also allows, because when you're, say, in a manic phase, you may actually not meet the criteria for civil commitment, as you can be really psychotic, but the civil commitment criteria had to do with dangerousness. And you may not be dangerous, you may just be, making terrible decisions. And in those cases, if you don't have a PAD, the doctor is really stuck because there's nobody to give consent and there is really no route potentially for involuntary treatment or other emergency procedures. And even if you suppose a person is dangerous enough that they say, okay, we're going to put you in the hospital, civil commitment, the 1013, the 1014, and the 1021 don't give you authority to treat. They just say you put in the hospital. You can go to the judge at the 1021 hearing and ask for an order to treat, and the judge can then give you an order to treat, and you can treat involuntarily. But you can't as a matter of course. And the 1021 hearings usually take 2 to 3 weeks before they occur. It's not like they happen the next day. So you've got this one group that really you can't treat under any sort of way. Now, there are emergency times when you can treat. Obviously, there are emergency exceptions and safety exceptions, and sometimes patients meet those. But there are also cases where they don't, and then you're sort of left hanging. And so the PAD really will help, it solves certain problems. From the doctor's perspective, I should have said at the beginning. So I'm a psychiatrist. I'm on the faculty at Emory. And I'm here really representing the Georgia Psychiatric Physicians Association, of which I'm a past president. Because of that, I got involved in this legislation back in the beginning. I actually testified in front of a committee, I don't remember which one, 13 years ago, at the first hearing. And I haven't testified on this bill since, but it's pleasant to be back. And I'm glad it's looking good. So from the doctor's perspective, the PAD does a couple things. And I'm also here to speak for the Medical Association of Georgia. The PAD does a couple things. First of all, it gives the doctor some sense of what the patient's wishes are, what's worked, all that kind of thing. And secondly, what it does is it gives the doctor consent, because you can't treat a patient except in certain fairly limited circumstances without consent. And the PAD gives consent, either by itself or through an agent, where the agent can consent for certain things. Now, the PAD may say, I'm not consenting, to X, Y, and Z. And if they do that, then you don't have consent for those things. It's not a blanket consent. The patient could say, I consent to valproic acid. I do not consent to lithium, or, various things. And with regard to the issue about preference of hospitals, it's a preference, but it's not determinative. It can say, I refuse hospitalization at X. Patient could write that, in which case you wouldn't have consent to admit them there. You might be able to using involuntary procedures, but it would be the same as if you had a voluntary patient who was competent, who said, no, I'm not going into that hospital. And then you would just have to deal with that with all the EMTALA choices and limited options and all that kind of thing. So, it gives you consent in a variety of situations, but there still could be some where you don't. And then you just have to, it goes back to how we handle things now with all those potential problems, of course. I do want to say one couple things from the patient side of things, which Dan mentioned. There's been a fair bit of research on the operation of these in other states, because quite a number of states have them. And generally, the research has shown that they're positive in the ways that people hope they'll be positive, which are a couple things. First, patients tend to feel empowered by having these, that they measure empowerment, that they like, that they get to express their preferences. That's important to them. Because particularly if you have a severe mental illness, a lot of times you don't feel very powerful in this system, and empowering is good for patients. Second, it has been shown to improve treatment adherence when the patient is competent. They feel more involved with their treatment. That does have positive effects on treatment adherence. Third, it decreases coercive treatment. I think that's what we've been getting to here, that situations where previously you had to civilly commit a lot of them, now you wouldn't have, they would be voluntary admissions, so it wouldn't be involuntary. And the fourth is there's some data that actually improves relationships among family members, that when a patient is talking, because usually the agent is going to be a family member, that they then are talking about what they want and thinking it through, and that has effects within the family, which are positive. So the research is generally positive about how these work. So I think those are the key points I wanted to cover.
How many states are we up to now? Probably that have advanced directives. I've sort of lost.
25 or 20, 28. I don't know. I'm
It's
not sure.
climbing.
Yeah, something,
Majority.
a little over half, I think. Yeah.
Have advanced directives. Okay, thank you. Okay. Do you have another question? No.
I apologize for monopolizing. There's not a shift in the ER that goes by that we don't struggle with this, with how to take care of a patient in a way that's compassionate with a system that may not have the resources that are needed. They don't have you on staff everywhere. I still have a little bit of a question. The involuntary transfer you mentioned, we've run into that before where we transferred someone, say by ambulance, but if they're voluntary and we transfer them, they can also tell the ambulance to stop and let me out 5 miles away. So we have to make a commitment in the emergency department that they're going to get all the way to your facility, which means the only way to do that is an involuntary commitment. And so Haldol, Geodon, the other treatments that we do in acute situations, if we're busy with our administrative staff trying to find out about an advanced directive that doesn't like to get Haldol or doesn't like to get an antipsychotic injection, I'm a little concerned to make sure, and I'm sure if it's done in 25 more states or more, it's probably been addressed and the problems have been worked out in the current bill. it's almost like if there's an exclusion for involuntary patients, once to the reasonable degree of medical certainty, we think they're a danger to themselves or someone else, or the other line on the 1013 about a mental illness that renders them incapable of taking care of themselves.
Right.
If it was clear that that situation is different, you don't get to exclude a receiving facility if that's the one that's most available in a timely manner for what you need. Just because somebody showed me an advanced directive or filed it the last time, I wouldn't want East Georgia Central Regional, excluded because you didn't like the way they treated you there last time, but that's the only place that's available. So I guess I'd like some sort of a clear line on involuntary in an emergency department in particular.
My understanding of the bill is that if involuntary procedures are in play, then they take precedence.
Okay, thank you.
That-
I think that will answer all the questions
And-
I would be receiving.
Yeah, both in, both in sort of in civil commitment proceedings, in outpatient commitment, and in court-ordered treatment, say in insanity defenses and those sorts of things. Yes, there's exclusionary language that says involuntary takes, if you have involuntary procedures, they take precedence. The idea of the PAD is a lot of, hopefully a fair bit of stuff that used to be involuntary now can be considered voluntary. And so you don't have the limitations that the involuntary rules have.
Thank you.
Well, and I think that things are busy in the emergency room. However, when it comes to stigma, there's a certain amount of stigma that goes when you have been involuntarily committed to treatment. And any time that we could or use the advanced directive to, circumvent that so that you go voluntary is certainly a plus in how society perceives this person and they perceive themselves. So, I mean, although not perfect, this is a means. And like Dr. Ash said, we really think it will, decrease the number of involuntary procedures and hopefully the people that hit your emergency rooms.
Yeah,
So-
specifically, it's at lines 267 and 268. A psychiatric directive shall not limit the involuntary examination, treatment, or hospitalization of patients under chapter 3 of this title.
And that would apply to my preferred and my refused facility
Right.
previous,
Right.
all of it just exempts. Thank you.
Right,
Perfect.
my way of thinking about the PAD is that that's what I want as a voluntary person when I'm competent and voluntary. But it would get kicked out if involuntary takes precedence, just as it does for if you walk in as a voluntary patient.
Thank you.
Okay, we had a question from Representative Hutchinson. She can't get her audio on. So the question was, is there something in Georgia code that prevents an advanced directive for mental health? And is this a legal issue or a practice issue? That's from Representative Hutchinson on Zoom with us.
Can you repeat the first part of that question?
Is there something in Georgia code that prevents an advanced directive for mental health? There's nothing that says that we can't put this into code.
No, I would have thought she might have been referring to in the advanced directive for healthcare, which is itself part of our code. It expressly says that the agent does not have authority to make mental health related decisions. That doesn't mean the legislature can't pass a law creating a psychiatric advanced directive for healthcare. So I'm not sure I understand, but the legislature can choose to pass a law that permits this if it chooses.
Can we see her? Representative Hutchinson, does that answer you? Can you give us a hand signal or something does that answer your question?
Yes and no. So I'm not clear. So if I decided I wanted to do an advanced directive for my mental health treatment, I can't do that right now. It doesn't seem like something that's illegal.
We don't have a statutory form that's consistent across the state. So people, for example, a couple of the groups that are in support of this bill right now,
I'm good.
do circulate standard template documents from other states, and therefore somebody can choose to do one here. Whether anybody honors it is another question. And I think a big part of why there's a great deal of support for this bill in the medical community is that a lot of thought has gone into the issues of liability and the issues that have been discussed already today, where at some point the hands of the medical community, the provider, might be tied, and to make sure that there is as little risk as possible for that, including limitations as to liability. And so I think that it is possible to do one here, but having one which has been adopted as our statutory form will go a long way to adding value.
It's basically the same thing we did on the advanced just on our regular advanced directive, because for years we didn't have one, and now we have a consistent one across the state.
Yeah, my sense as a clinician is if someone showed up today with a psychiatric advance directive, which was in opposition to what they were saying when they were sitting right in front of me, I don't know that I could rely on the psychiatric advance directive as a legal consent. There isn't any clear authority to do that. And what this legislation does is gives that authority. So I can say, okay, yes, that's a valid consent. I can rely on that and we can move forward.
That take care of it, Representative Hutchinson?
Yes, it did. Thank you.
You're welcome. Representative Schofield? Okay, sorry. Who is it? Oh, Representative Sharper.
Okay, thank you, Chairman. And thank you guys for being here, bringing this information to us. Going back to Dr. Newton's concern or question, your example, can you kind of repeat that? You said that, was it voluntary or involuntary? You say that if a person came into the hospital and they was being transported and they would, make a decision not to continue. I'm wondering if the COBRA itself would, kind of help keep the transportation unit responsible to say, okay, if it's voluntary or it's involuntary, you can't change that part. If it's voluntary and they say, well, I don't want to go to that particular place for whatever reason, I think at that point we would be in a position to say, we got to call law enforcement, call the hospital back, to see what we need to do, because we wouldn't be able to just let them out. You get what I'm saying? Because I'm thinking we're still on the COBRA from the facility to another facility within that, So.
Yeah, it's a challenge. Some of these are hundreds of miles away.
Right.
There are ample opportunities, and then the concern with we've left the paramedic, for example, in a situation to where they don't have the authority to stop or call the police or anything. If somebody does change their mind on a voluntary transfer, whether it's for appendicitis or mental health or anything else, they can stop the ambulance and get out and do whatever they want. And so we run into that on occasion with our transfers. So we have to make sure that until they arrive at a trained psychiatric facility, that covers the whole process to get them there. And it does as best we can guarantee that they will get to where. I'm not a psychiatrist or behavioral health expert, so it guarantees they will get an official evaluation in the same way if we were transferring an orthopedic or cardiac patient. It ensures that they'll get there and they can't change their mind midway. But I think it sounds like this is dealt with our involuntary examination and treatment perfectly well with the language here, to where that shouldn't be an issue with the typical emergency department psychiatry visit. And it will actually help in some of the ones where you've mentioned about the preference of medications and all. We know we can already have consent, as you say, even if they're in a manic state.
Well, I got a quick question on that then. Even if it's voluntary and that person's going to that facility, okay, at that point where that person say, look, I've changed my mind, I don't want to go, we would have to know that, okay, hold on, even though it's voluntary in your state of mind when you left where you were going to the facility, but now you're getting ready to change over, that involuntary may not be, it wouldn't just go from voluntary saying, I don't want to go. It may be something changing in that patient to where they're finna go into a crisis or some type of, different mindset, if you will, to say, now, you were normal, but something's going on the trip, doing something to you. Now your mind's going, and now that's in a position of, hold on, this is no longer voluntary. This is flipping into, is getting ready to have to be involuntary. So at that point, we would have to stop and call the, possible law enforcement or call that hospital, the receiving or sending, and say, what do we do in this situation? Does this give us a situation, or will this help that patient knowing that they have this on file to say, we have this on file, it's been it's been communicated to us that this is on file, that this person is getting ready to go into a crisis. We can't just let them do AMA or, against medical advice and leave on the side of the road and somebody pick them up. But will this help protect that situation to where we send something that's going on with this patient is no longer voluntary, and we need to involuntary, whatever's in place.
Right. My own sense of how that would work is that I don't think the ambulance driver can sort of make that determination, but I could see a situation where someone is in an emergency room and they're saying right then, okay, I'm okay to go to this other place. But the clinician says, well, great. But they're thinking, this guy's pretty unstable. He might change his mind on the way. I could potentially, if he meets criteria, sign a 1013 form, so it wouldn't matter. But I've got this PAD that says, yes, I want to be examined. So now I've got consent for this transport on the PAD. So you can tell the ambulance person, we've got consent, and he can't change that because it's in the PAD. We have prospective consent.
Mm-hmm.
So that would then, if he started refusing halfway there, the PAD, assuming he was, the clinician directed him to it, I think you could say from the PAD, sorry, your refusal doesn't matter because we found you incompetent to make decisions in the ER, and the PAD says you consent to this, where we're taking you to this transportation, so it would work that way. You see
Okay.
that?
Yeah.
It doesn't solve the problem of what happens if the clinician didn't anticipate that there might be a problem. I mean, that could happen now. And then
But
that's a
probably
problem.
since he did bring it up, that's something that could be a reality of once that person's going, en route.
Right.
and
You
start
could
changing
tell
their
the ambulance
mind.
driver, we're not for, when we're saying this is a voluntary transport, we're not relying on what he's saying now
Mhm.
because we think he's incompetent now. We're relying on what the PAD says.
Okay.
Okay. And that then doesn't go away when he happens to change his mind.
Okay, good.
Is that
Yeah,
clear?
I
Okay.
wanted to make sure that, possibly that was in there to cover something like that.
I don't think it addresses that particular thing, but that's the general principle. Once
Right.
you have once the person is deemed incompetent to consent, then the PAD takes over and whatever is there counts, and his refusal in the moment doesn't count. That's
Right.
the basic principle.
Okay. Thank you.
Representative Hawkins. Oh, sorry. Hogan, sorry. Right.
Thank you, Madam Chair. I appreciate y'all being here, and it sort of brings a little bit of a different light to what I've been used to over the years. I was a licensed mental health counselor for years and years and years working out in the field. Does this do anything for our jail population? Because Department of Corrections is the biggest mental health provider in this state right now. We got about 70% of those individuals in county jails and in the Department of Corrections who have a mental health diagnosis, and nobody's doing anything for them. The Department of Corrections is not a mental health facility, and our county jails are not. So we got people really suffering in our jails out there. Does this do anything for that population?
So my own understanding is that if an inmate had signed a PAD, then yes, that would be giving consent.
Under this legislation?
Yeah, it's not that people in corrections are excluded from being covered or being able to sign one of these.
Madam Chair, this is a legislation in other states right now, right?
Yes.
And how has it worked with the jail population in those other states? Has it had any implication at all on trying to help?
Can you be more specific on, I mean, they're in jail, so they're under they're
And there's no,
created,
and there's no mental health facility at all for those individuals who are being abused in the jails.
right? And so are you asking, is this going to get them out of the jail to be taken somewhere else? Or,
There's nowhere else for them to go.
okay, so what? do
I'm
you-
wondering, in other states, has it done anything to alleviate the jail population who are mentally ill?
I'm not aware of any studies, there may be some, on the use of the PAD in a jail population. Now, Department of Corrections provides mental health services in theory for
In
inmates.
theory,
That is, in fact, prisoners are the only people who have a right to health care. Right?
if you have the people to provide the
Well,
health care, the
but-
mental health services,
Right.
which
But
we're
then
very,
that-
which
that's-
we're
there's
have
lot
a
of
shortage that's unbelievable.
There's a lot of litigation, as you know, about, I don't know how much in Georgia, but in other states about getting health care to people in correctional facilities, but they do have a right to it. And the test is whether the correctional facility is having deliberate indifference to their healthcare needs. That's a constitutional violation if there's deliberate indifference.
Thank you.
And I don't see that the PAD, again, it would essentially provide a consent to treat a prisoner who might otherwise be refusing, say, if he went manic while in his cell. Yeah, but I'm not aware of any that have actually looked at like how many inmates have signed PADs and that kind of thing.
Thank you.
And Representative Hogan, I guess we're taking one bite out of the apple at a time. I mean, this is not a bill to solve anything. And I think that we have seen from the pandemic, just how widespread mental illness is, or substance abuse, maybe that a lot of people skirted by under normal circumstances where people didn't realize that, they were sort of on the borderline and could handle their mental illness without other people knowing about it, or their addiction. And the pandemic has brought to light just how many people in our society do suffer. And this would help people in this issue, but we'll have to work on the ones on your jail population.
Yeah, we have a lot of people that are in jail that have caused a minor crime or whatever
Right.
because they would not take their medication. And they've been acting out, and the first place they go is the county jail.
Right.
So,
It's a problem.
Right.
Representative
I'm-
Newton.
my service runs a unit in the Fulton County Jail. We have a pod that we're responsible for, so I'm quite familiar with, at least in Fulton County, the health issues.
One of the things I just, we haven't talked as much about because of some of my questions and others, but it really looks like the agent piece of this may be a large part of what helps you do. So once someone has been gone from capable to incapable, then the agent can step in the same way when someone's intubated, they can step in and help make the decisions I would have wanted made had I still remained capable. I wasn't in my manic episode. And I think that maybe tell me just a little more. Is that one of the pieces of this that's the sweet spot, or the really exceptional piece of it is to have someone who knows my situation, who knows my desires. And I've even given them authority to make decisions on my behalf if I'm in that manic episode you described so well. I think that might be really an amazing piece of this. If am I reading that right?
Yes, obviously, if you just have a document that says I consent and this and that gives you some. But if you have an agent, then you can have discussions, because obviously things may come up that weren't anticipated and all of that. And you've got the agent who's
They can
familiar
receive
with the
information,
person, and they
right.
can use their substituted judgment and make decisions. Yes.
Thank you. I like that a lot.
Okay, we'll go back to you, gentlemen. What else would you like to add? Would you like to?
I would just like to add, to run through a list of some of the different organizations that have decided that they want to support this bill. I think it's a pretty broad snapshot of society overall. And one of the differences between the 5 prior bills and this bill is that for whatever reason, the bar got involved, and then through the bar, the fiduciary law section, we had an opportunity to bring a lot of other stakeholders to the table. And so this list, I think, might be illustrative of the broad support we have so far. So obviously, to start with, the Georgia Psychiatric Physicians Association, Georgia Psychological Association, the Georgia Mental Health Consumer Network, Medical Association of Georgia, the Georgia Advocacy Office, Resilient Georgia, the Georgia Parent Support Network, the Georgia Behavioral Health Services Coalition, the Carter Center Mental Health Program, the State Bar, and then two fairly significant ones, the Mental Health America of Georgia chapter, as well as the National Alliance on Mental Illness. So essentially a who's who of all of the different mental health related organizations have all had an opportunity going back to March of 2020. So pushing 2 years is when this fiduciary law section subcommittee was created, and we started bringing all those groups to the table. All of them had the 2017 version of this bill, which is the last time it was introduced, had an opportunity to offer feedback, request changes, discuss changes, and now have all agreed to continue providing their support. And as you see on your white paper, all those logos are present. And so we're not especially aware of any particular opposition to the bill. We're waiting to hear about that. And if we need to address it, we so far have received only support.
The bill has been out there in ample time for people, if they were in opposition, to raise that opposition. Because this one's been floating around at least for a couple of months, and my office has heard from no one. And on that respect, and certainly, if it was a burning issue, I would have thought that I would have heard from people by now on this issue. Did you have more that you would like to add? Certainly, your comments.
Reference a couple times has been made to the Advanced Directive for Healthcare, which was created in Georgia in 2007 to replace the old living will and the old durable power of attorney for healthcare, and that I believe has been largely successful. And a fair bit of the legal operative language and the form itself is based in part on that form. And Dan mentioned that the existing Advanced Directive does not cover mental health. It's worse than that. It's ambiguous about how it covers it, because to use your diabetes analogy, you would wish that mental health fell under the same category as healthcare in general and was covered by it. But I think Dr. Ash, who said he'd be reluctant to rely on a psychiatric advanced directive now, is probably wise, because what the legislative language provides is not just a form. It provides a legal framework for third parties, healthcare or health providers, to honor the form, to work with the form, to understand liability under the form, to understand the role of the agent under the form, what powers that agent has, things like revocation and the ability to do a new form. All of that is what's important as well. And right now, it's very ambiguous as to how the general Advanced Directive for Healthcare deals with mental health and the developmental disabilities and the substance abuse as well. So this does fill a gap, but we used it as also an opportunity to make sure it was clear about the relationship between the Advanced Directive and this form as well, so that we weren't going to create any kind of conflict between those that were intending a form to cover mental health, but now have the ability to do this more specific form as well. So that's where the lawyers got to assist with the doctors in doing this.
I think one of the things too that I've, being a psychiatric nurse, is that with being able to have the history, or to say that even though if I'm in a manic stage, they tried lithium and it didn't work, and the time that would save a physician who doesn't know the patient, so that because that would be, I think, almost the first drug that they would go to, and thinking they could, take care of this, and to bypass that and to get them a medicine that did work quicker is one of the real advantages of this being able to know how this individual, because, you know, medicine is an art, not a science. And the same medicine works very differently on one patient and then the next one. And so it is finding that spot and what works with each individual patient. And the quicker we can do it, the quicker the patient gets relief and the less, you know, cost it is to the patient or their family and to society as a whole. If, you know, if knowing that I've reached that manic stage, if you give me a certain medicine, it'll start working. And not to be in that manic stage, even though usually they are very happy and giving away their money and enjoying the world and telling you they have all the world's problems solved if you just ask them, can't really feel good. I've never been in a manic stage, but it seems like it wouldn't be a particularly good feeling. And so I think that, you know, just for the patient's well-being is certainly a benefit of this. So questions from the other questions from the committee? The presenters. Okay, we had Mary Lee Boatwright Quinn that wanted to make comments.
Yes, Madam Chair, thank you. Can you hear me on here? Yes, you can. So as Madam Chair said, I'm Mary Lee Boatwright Quinn, and I'm with the Alzheimer's Association Georgia chapter. And on behalf of our constituents who oftentimes in the middle or late stages of dementia can express some behavioral problems due to their disease, and unfortunately oftentimes find themselves in a psychiatric institution for those behaviors. We just want to make sure that this doesn't have unintended consequences on our population. So it's not that we're against this bill, but I have a couple of questions just to ensure that that doesn't happen, if it's okay that I bring up those questions.
Here.
So one question is this, you know, somebody with dementia doesn't realize that maybe later in their disease, they're going to act out and end up in a psychiatric unit. So they may not think, I need to fill out a psychiatric advance directive because at one point I'm going to have to need it. So they may not have this form completed because they didn't anticipate, because they don't have a persistent mental illness per se, they have a disease. So what happens, for example, if somebody completes, they have an agent named in their advanced healthcare directive, but they have a different agent named in their PAD? What happens then?
I think that you made an excellent point that there's a difference between a mental illness and dementia. And so I think that anyone who's in the medical field who's treating somebody who's suffering from one or the other, hopefully will be able to recognize that difference. In terms of the question about the two documents, maybe not 1,000 hours, but 1,000 hours went into finding every possible way that the two documents could impact one another. And in all cases, clarify which one will have precedence. And so the two documents together and the statutory framework behind the two template documents specifically say that in the case of a mental illness crisis or in any other of the triggering events, the agent under the PAD has authority, but otherwise the agent under the Advanced Directive for Healthcare has authority, which obviously brings us back to the difference between a mental illness and dementia and the fact that there could be a dual diagnosis, which I know maybe Dr. Ash can talk more about, but the way that it's supposed to work, and I don't know that any bill is ever perfect, but the way that it's supposed to work is that there is a bright line drawn between the two documents, and there should never be a scenario where there are competing agents taking a different position. There's always an express priority for one versus the other as to who has authority.
So if they had a healthcare advance directive and they had an agent, you're saying, and they didn't have a PAD, then that agent would have priority. But what if a family, like a child went and got, they already have an advanced care and they didn't know about the PAD, but some child who wants to have control of mom and dad goes and fills out a PAD and becomes the agent there. and then they end up in a psychiatric unit, then now the healthcare, the one that was named in the healthcare document that may have been done when they were, you know, of frame of mind to name them, what happens there? I guess I'm just wondering if, could it ever be used in a family as a tool to like take over? I'm just curious.
I think you heard the lawyer say there's no perfect bill. And as
Yeah,
we
I'm
look at
just-
all bills, there's always what if. You know.
Yeah.
Okay.
And so, I mean, that kind of also brings to mind the question, and again, I'm not against the bill. I'm just wanting to make sure you guys understand that people with dementia, Madam Chair, unfortunately, and I have a whole nother study going on about something we might bring forth, because people with dementia do find themselves in these facilities. And oftentimes this might actually be helpful to them, because there are drugs that people with dementia should not be given, psychiatric drugs. And unfortunately, some of our psychiatrists don't know that. And so they end up, and you may even be able to speak to that, that happens. So this could actually be helpful to somebody. I'm not saying that it couldn't, but I just want to make sure that, so if you were to have a pad, is a pad only for people who've already been diagnosed with a mental illness? Can anybody fill out a pad, or you have to have a diagnosis of a mental illness?
Well, as I understand, in theory, anybody could fill out a pad, but I don't know what you'd put in it if you, you know, what drugs you'd say worked and didn't work if you really didn't have any history of mental health treatment. So
But
the
part of it-
idea is, I mean, the idea behind it is that it would be filled out by someone who has a serious mental illness at a time when they're doing well and can make reasonable decisions.
Right. And so, and I just wanted to bring your attention to, and I'd love your comments on this, on Virginia's way that they handled this was, instead of creating a new form, they actually, you know, they edited their healthcare advance directive to have a Ulysses clause so that somebody with a persistent mental illness could check that, complete that section of the form. Why are we not just adding that to us? Why do we have to have an additional form, which could be burdensome to somebody like somebody with dementia who maybe isn't anticipating what they might experience later in their disease?
Well, why would someone with dementia be filling out a psychiatric advance directive?
That's what I'm saying. I don't know
Because,
why,
in your
why
example,
they
you said
would.
if the child went and got one, but the child can't get one. The patient has to be competent when they complete the psychiatric advance directive. So if they're already demented, they may be past
Well,
being able to complete it.
They could, but early stage dementia,
Early stage they could,
absolutely,
sure.
you can complete
Sure,
advanced
Sure,
directives.
early stage you could. Although I think, I mean, typically Alzheimer's is dealt with by neurologists and people like that, who I think typically, I mean, I don't know a lot. I know the ones I work with, but will encourage patients to do a healthcare directive and work that out.
Absolutely, we do
And that
too.
then usually is what controls. And that would be the usual situation, I would think.
And so if that person ended up in a psychiatric facility,
Then
and
they
they
would,
didn't
I would
have a
think they would have
pet
authority.
pad.
Yeah, they would. Oh, yeah. It's not like if you're in a psychiatric facility, the healthcare directive doesn't, that agent doesn't have anything to say. No, that's not the intent at all. It's not
Okay.
like you only have, you know, the psychiatrist. It's not that the psychiatrist will only listen to a psychiatric advance directive. We listen to healthcare directives all the time.
Yeah.
Now.
Well,
Okay, well,
and I wanna
again,
com-
I just wanted to make sure there weren't any unintended consequences.
Well, and I
Yeah.
would also comment on the law. And Georgia's law is very different from Virginia law. They're a Commonwealth, totally different system. The other thing is you saw in the bottom of here, and over the 13 years we worked on it, you know, many of the people that are involved with patients are more at ease or comfortable with us being very specific in the way we handle this and spell out how they want to be treated. And then just a short form that you click on and add to the other thing. And under their guidance and over the years, this is what has been worked out to the point that we could get all of these groups to come together and say that they are behind this bill and that it, you know, that it's a good bill and that we need it. So It's,
Again, I 100% agree. People with persistent mental illness, this is a great bill. We should be having the ability to set forth, our wishes. Again, we don't want, because unfortunately people with dementia do get 1013 fairly frequently.
well, I think to add to Dr. Ash's, and I'm not a physician, I'm a nurse, but I'm not a physician. It would be my understanding that they would be evaluated when they are admitted to the hospital, that the fact that they had dementia would be, right, that's what I wanted to say, would be recognized and would then supersede that the mental illness is coming from the dementia and some stage that it's in.
Or
And
the
therefore
behavior.
treated that
Yes,
way.
the behavior.
Right.
Okay.
But there's always going to be, no matter what we do and how perfect we try to make a bill, there's no way anybody can ever say to you that that won't ever happen, or that we could write a bill that
Agree.
would never say that a person with Alzheimer's might not end up, in a psychiatric facility being treated for that and missed. But that's certainly not the purpose of this bill.
May I ask a question about that? Even if they are, how is this a bad thing that a PAD exists and that there's an agent with the authority to weigh in on their care?
It's not necessarily a bad thing. I was just saying that a person with dementia may not, they're going to present in a psychiatric facility, right? But they may not have had, they don't have a mental illness, so they didn't fill out a pad. So they're not going to have, the advantage of having those wishes. And if there happen to be two different agents named, that could be problematic. That's what I was concerned about.
One analogy, I think, to the issue of the possible agent conflict, which
Mhm.
I can imagine a scenario where that may come up,
Mhm.
is if you think about what would happen if you have a child in the hospital and one parent says, do this, and the other parent says, no, do that. Because each parent can consent and essentially they're and if they conflict, then there's an issue. And it would seem to me that your situation would be a similar kind of issue and would probably get resolved in a similar sort of way.
Mhm. Okay. And I guess you all looked at just editing our current statute rather than creating a new form, and that was not a viable option, you didn't feel like?
I answered that question for you in the fact that this was after many, many years of discussions and, working together with the different groups, that this is the direction that they chose to take
Mhm.
for the Georgia law.
Thank you, Madam Chair.
You're welcome. So Stan, did you want to testify or have questions? Or I'm not sure we got a sign-up sheet. And if anybody else did that we didn't get a sign-up sheet for, after Stan gets through, just let me know.
Good afternoon. I'm Stan Jones with Nelson Mullins Law Firm. I'm here in two capacities, I suppose. So one, we do represent the Georgia Psychological Association, and they're strongly in favor of the bill. I would say, as been around the mental health stuff for a long time, this gives more information to whomever the treating physician or psychologist is about what's happened with the patient over time. So it's a good thing, and it also empowers patients, as the chairman said. And then secondly, I'd just like to say, in response to Representative Hogan, this won't be the only mental health bill. And of course, the chairman, Representative Hogan, others have their own bills that deal with it, and the Behavioral Health Commission that deal with mental health parity, with transporting people directly to care rather than going through the jail, with working on workforce issues, and we're going to need more money. How providers get paid in mental health affects how many are available to help. And so you're going to have issues with Medicaid, with DBHDD, with corrections and all these. This is the best year we've ever had in the 50 years I've been around to do these things. So this isn't the only bill, and I don't think it'll become the substitute for any of the others. I just wanted to say all that out loud. I'm not sure it needed to be said, but Representative Hutchinson's got a parity bill. The commission's going to have a parity bill. All these things are vitally important.
I'd like to say that I think that the speaker put a lot more money in the budget this last year and said that he would be putting more money in the budget this year for mental health. And that is a major step forward as we try to make 2022 a year for mental health. So thank you, Stan, for pointing out that there are lots of bills coming. And I know that, you know, the fate of our citizens with mental health issues is very important to the members of this committee and members of our General Assembly, and certainly trying to elevate the level of care that we provide for them here in Georgia. So I'm proud of the work, and especially when the speaker put money behind his statements, and for that commitment, and the governor's commitment for it too. And of course, we care about people with Alzheimer's. I'm hoping that, you know, maybe soon you won't have a job. Not really, but I speak of the new medication that they're now looking at. I know it doesn't cure it, but maybe it'll be the first step toward making a major difference in the treatment of Alzheimer's. I was just teasing about your job. We should live that long that we see Alzheimer's eradicated from the face of the earth with medication or treatment. But at least for the first time ever, there seems to be something questionable. I know there's two sides to it that may be helping slow down the process of Alzheimer's disease, which is between diabetes and Alzheimer's. If we don't get them under the control, I think they're probably going to break the bank of the country before it's over, as we have an aging population and a population that increasingly has severe diabetic problems with it. Other questions for the committee before we let these gentlemen in, other than to say how much I appreciate y'all working on this, and the bar taking it on as an issue to help us solve it. And Dr. Ash, hopefully we're getting close to the closure on this, and you can actually see it in action and working on people using this. And one more step in helping do away with some of the stigma to mental illness. And with that, anybody else? If not, thank you guys for coming and staying, and we are adjourned. Thank you.